So today we are talking about Muslim divorces in Singapore. The Sharia Court of Singapore will have jurisdiction over marriages between two Muslims domiciled in Singapore. Before commencing any divorce, you need to have attended the counselling sessions under the marriage counselling program. If you have children under the age of 18, you need to submit an agreed parenting plan or proposed parenting plan to the court with the help of marriage counsellors. So the requirements to start a divorce proceedings under Sharia law are different depending on whether you are husband or the wife. As the husband, you only need to state your intention to pronounce talaq or divorce in Arabic, which means to release. It allows the husband to apply for divorce without actually proving that the wife has done wrong. However, if the husband has already pronounced talaq, the wife only needs to seek registration of the divorce. She can indicate this when applying for divorce in the registration form at the Sharia court. The flip side of this is the wife's application to seek divorce. She can do so under the ground of khuluk, where she is required to prove that the husband has done wrong. She is required to compensate her husband through monetary means. If the husband has not pronounced talaq, a wife can only apply for divorce on other grounds, for example, by fasaq, taklid, which essentially means that the marriage is annulled, or if there is a breach of condition under the marriage certificate. So similar to civil divorces, Sharia divorces also raise issues of custody, care and control, and division of assets. However, two key differences lie in the aspect of maintenance. In Sharia law, iddah is a concept where the wife has to be compensated for the 3-month period in which she is forbidden to marry, whereas muta'ah is global compensation to the wife based on the total length of the marriage. And so these are the brief grounds for divorce today, and we will continue shortly in the next episode.